all the allegations against the governor?
Yes, I can.
Therefore, you will agree with me, utterances by the governor, even though you are a chief of staff, are not your utterances.
It's true.
The things going on in the governor's mind at the time of making those utterances will not be also going on in your mind, correct or incorrect?
It is correct, but I need to say only God can know what goes inside someone's mind.
Fair enough. The motivations, whatever they are, in the governor doing any of the things she is alleged to have done will not be your motivations because you and the governor are different persons. Correct or incorrect?
It's correct.
You must agree with me, therefore, that you're not competent enough to respond. That is what you pleaded in paragraph 3 of your affidavit. You must agree with me, you are not competent, as you claim, to respond to all the allegations against the governor.
Through the chair, I also need to say this. When someone is represented by a lawyer like you, there is a possibility that when you get the information about what your client is for, you find that information, and even you, currently, you are engaged on the information that you got from your client, and that's why you are representing you. Because for sure, even you, I'm very sure, you cannot know what was the mind of the person or the mover of the motion. We are here as witness and to represent our client because the law allows us to do that.
Chair, since the witness will have the opportunity in re-exam to explain, I crave that you direct him to just answer my questions so that I don't take longer than the time you have allocated me.
I think a witness, that is important. Make sure that your response is directly in proportion with the question.
Noted, Chair.
The governor has faced a number of accusations, sir. Let's begin with the appointment of the husband. Is it your position, sir, the governor never made the utterances we saw on video are making?
She made the utterances.
Good. So the only difference between you and me is our interpretation of those utterances, isn't it?
Yes, through the chair, the utterances are not in dispute to any party.
So do you agree with me that the only contest between the two sides is not whether the utterances were made, but how we have interpreted them vis-a-vis how the governor has interpreted them?
It's true.
You will also agree with me, sir, that the second point of departure is not whether the utterances were made, but whether they were followed by official letters of appointment.
That's true.
Sir, would you expect people watching the governor making utterances of the type she was making to take them seriously?
Pardon?
Would you expect the ordinary citizen to take utterances by the governor seriously and specifically on their face value?
Yes, I do.
If the governor announces on national television or regional television that she has appointed her husband to some office, would you expect the ordinary rational person to take her seriously?
I expect to be taken serious. I want to add, there is no denial that she did that.
Order witness. Counsel, help us. You cannot expect the witness to testify on the opinion of other people. Limit him to his evidence and poke holes in his evidence. But to ask him now to give us an opinion on what he thinks the whole county was thinking, we shall be stretching him.
Let's come to our point of divergence on the issue whether the appointment letters were issued.
They were not.
Are you a member of the County Public Service Board, sir?
I'm not.
Are you the county secretary?
I'm not.
You must agree, therefore, you would not be the person to give the best evidence as to whether the appointment letters were issued or not.
Through the chair, I did communication to all those offices, and the letters or their responses have been attached to the response that governor gave. So my responsibility was to do an investigation, of which I did. Because I cannot be everyone, I cannot be every person, but those persons that are responsible, I did my duty, and they confirmed the same.
Chair, if my colleague could show the witness volume 2 of our battle at page 29.
Counsel, are you referring to your bundle or ours?
Ours, volume 2.
You can share yours. We do not seem to have it here.
What you have there, sir, before you is a printout of section 56. My interest is in subsection 2 of the County Governments Act. Can you read it for us?
The county public service shall be ended by a county secretary appointed under section 44.
You will agree, sir, that is the person competent to confirm to this Senate whether there is an appointment letter or not.
Through the chair, if you look at all the letters were copied to the county secretary to
That's
confirm.
not my question, sir. Based on that section, wouldn't the county secretary be the person legally qualified to tell the Senate whether or not an appointment letter was issued?
Probably it is good to differentiate between the office of the governor and the county public service. There is a difference.
I didn't ask about the differences. Please answer my question. If you don't want to answer it so that we move fast, just say you don't want to answer my question.
County secretary can confirm about the public service, but the chief of staff confirms about those that are employed in the office of the governor.
Are you aware the motion is about appointments to the county public service, not to the private office of the governor?
It is misplaced because the people that were mentioned are supposed to be those people in the office of the governor.
Let's come to the office of firefighters in the county government of Meru. Would that be an appointment in the office of the governor?
Yes, it is.
I put it to you, that, sir, that it is not. There is a firefighting department. It is not an office in the private affairs of the governor like the advisors and the chief of staff like yourself.
You can confirm for Meru County is a department that was put under the office of the governor. You can confirm.
The Meru Youth Service, is it a body created by law?
Yes, it is.
Does that law specify the offices of that institution?
Yes, it is.
Now that you say there is no dispute, the appointment was declared, are the offices in the Meru Youth Service offices in the private office of the governor? Is that your testimony?
My testimony is that what you're discussing is about the appointment of the first gentleman to an existence position. So the position is nowhere. It is not either under the public service or in my office. I needed to confirm that it is not in my office because an existing position, you cannot put it anywhere.
But you confirmed the utterances were made in the rally in question, isn't it?
Yes, I confirm.
Those utterances, wouldn't they, if they were to be taken seriously, be violative of the law establishing the Meru Youth Service?
It is not related to Meru Youth Service in any way. That's my take.
To the best of your knowledge, sir, does the law establishing the Meru Youth Service have the office of patron?
It has not.
It is not.
Yes.
Still on the letters, sir, who ordinarily would be the custodian of the appointment letters if they were issued?
The Public Service Board.
The Public Service Board?
Yes.
Who else would be having possession of such a document?
Myself.
Yes.
Yes.
Who else? The appointee in question, isn't it?
Yes.
You'll agree all these are people naturally aligned to the executive arm of the government, right?
Yes.
Good. You will agree matters to do with employment and HR, the assembly will not ordinarily be in possession of appointment letters of staff of the executive.
Through the chair, the responsibility of proof lies with the county assembly because they have powers to summon everyone to get that details.
My question is, in the ordinary course of human affairs, would a stranger be in possession of HR documents like an appointment letter?
Any public document is available on request.
Good, on request. Therefore, sir, you will agree with me, there is nothing unusual in the ordinary course of events in the assembly either not having possession of the appointment letter or encountering difficulties in accessing it.
Pardon?
You will agree with me, it is not unusual for the assembly not to have in its possession appointment letters belonging to staff in the executive arm.
I don't agree because an ignorant to the privilege that you've given cannot be a defense.
It is not unusual for the assembly not to have in its possession appointment letters belonging to staff in the executive arm.
I don't agree because an ignorant to the privilege that you've given cannot be a defense.
Chair, again, if the witness would answer my questions, I think he's too keen. He doesn't know you'll have the opportunity. I don't want to be making the interjection. Let's go to the appointment of Rufus Miriti. We've now left the husband. You will agree with me, sir, that the only contest between the two sides is not whether the appointment was made, but whether it required the approval of the assembly. Am I correct to say that?
You are correct.
Is it your case, sir, that that approval was not required?
It was not required. It was just a reappointment that has ever happened in other situations.
I will ask you, sir, to read the definition of appointment in the County Public Appointments County Assembly Approval Act. Chair, that will be at page 48 of our volume 2. Have you reached page 48, sir?
Yes.
Can you read for us the definition of appointment at section?
For which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act.
So the law says an appointment for which approval is necessary shall not be made unless the approval is sought, isn't it?
It's true.
But you read section 4, you were ahead of me. I asked you to read the definition of appointment in section 2 on the same page. Please read what I asked you to read.
Appointment includes any reappointment to the same body where or not in the same capacity.
You will agree these sections, sir, show, contrary to the position you and the governor have taken, that this appointment which you concede was made actually required the approval of the assembly. By the law you've read, was that approval required?
It was required.
Good. If it was required, was it sought?
I need to emphasize on this through the chair.
Please answer my question. It's yes or no. You have agreed the approval was required. Was it obtained?
It can only be required when it is
yes or no, unless the chair rules me out of order. Was it obtained or
it
not?
was not obtained.
Good. It was not obtained. I will show you page 186. You just read the statute. We now want to see what the courts have ruled on the matter. Chair, I'm referring to volume 2 of our Bible, page 186. It's a decision, Chair, that begins at page 170, but I'm only interested in the conclusion the judge arrived at, which is at 186.
Honorable Chair, with your kind permission. Yes, what is it?
Honorable Chair, the concern is that this witness is being taken through a course to offer opinions on possessions of the law. I think that is a matter for lawyers, and he should first of all have confirmed whether he tackles or handles matters of law in the office he said he serves in the county. Now he's being told to interpret a judicial decision, which, my lord, may not be within his competence, because it's a matter of law, and any other witness, including the governor, would not have testified to that because it's not a factual matter. It's a matter of law. I think the witness is being oppressed to be required to offer a legal opinion. He has no training in law, my lord. Thank you.
Counsel, don't overprotect your witness. Your witness is a very competent man. I think what the counsel for the county assembly is asking for is not a point of law. He's not even seeking an opinion. It's a fair question. Let the answer be on record. We shall interpret it. Don't overprotect him. He's above 18.
Most obliged, sir.
Through the chair.
Even asked you the question, sir. Please read for us paragraph 105 on page 186. It's a matter about the county assembly appointments, just like the one now before us. Please read it.
Paragraph
105.
It was, however, contended that since some of the petitioners had been approved by the previous assembly as the first respondent and its predecessor were exercising authority as the trustees of the people of Kenya, and more specifically the resident of Machakos County and Article 73 of the Constitution. It was thus surprising how the same constitutional body can arrive at two different reports on the same nominee for a similar job description. This issue brings to force the question as to whether the county assembly differently continued from this previous one is
I think it's constituted, sir, not continued, unless it's
constituted from the previous one is bound by the decisions made by the previous assembly in approving the nominees. If this position was true, it would mean that those who were serving in the previous government would automatically qualify for approval by the assembly once nominated by the governor. With due respect, if this was the intention it would have been precisely stated in the registration. This court cannot lead in such a drastic proportion of law which is not expressly provided in Alfred Mahandi, Ngome and others versus George W. SENTATE and two others, civil application number NAI 268 of 1999. It was held that
You can even leave it there, sir. You will therefore have to agree whether it is by reading the statute or reading the case law. The appointment of Rufus Miriti required the approval of the assembly. Now that we are not in contest, the appointment was made.
That's what I want to make clear.
Now the question, would you agree, sir? Would you agree, based on the case law you've just read, based on the statute you just read, that contrary to the position you've taken, this specific appointment was illegal for want of county assembly approval?
I want to make this through the chair.
Please answer my question, sir. You will get the opportunity.
Order, counsel. Relax completely. I think the witness wants to help us. Just allow him to address the chair. Witness.
Through the chair.
Chair.
I want particularly to mention the issue of Rufus Miriti. Rufus Miriti was the county secretary for the previous government. That is the former government. When the current governor came in, she extended his term to complete the handing over that was taking place. In all the situations that you've faced, for the county secretary, who has been the custodian of the former government, you just extend some time for him to continue serving so that you can get all the resources, all the requirements, or anything that you need. And that one is allowed by the county secretary, being the secretary of the transition committee that is always there to ensure that there is a smooth transition from the older government or from the former government to the current government. That is what happened. That's why there is no appointment letter for Rufus Mereti that is available, because the extension was for, that's not a reappointment but extension, so that time will allow the governor to form the government and thereafter appoint a substantive county secretary that will be forwarded to the assembly for approval. That is the case. There is no letter. Is an extension that is allowed even by the transition authority, whereby the county secretary is the one that is in charge of handling matters before the governments are formed.
This idea you are now introducing from the witness box.
Counsel,
Yes.
I think the witness wanted to help us. You are helping us. Now you've boxed yourself. Do you have a letter showing that that extension was given?
The witness has confirmed, and the documents filed on the record show it is common ground. The appointment was made. What is not agreed is whether that appointment required the approval of the county assembly. The clarification the witness is now offering from the doc that this was a transitional arrangement. That is not the position taken on the pleadings. That is not the position in his affidavit or the governor's affidavit. It is a completely new position taken from the witness box, but not from the pleadings.
Chair. Yeah, I sympathize with my classmate, but counsel, that is a problem you have brought upon yourself. Because after reading to the witness, the law, he is on record saying that yes, this is an appointment that required parliamentary approval or the approval of the assembly. Why you then pose the question again to him is something I don't understand. But here perhaps to guide the process, because the witness has alluded to a specific time, let him tell us or tell the committee how long this appointment was and where we can find that detail in the documents that are before us. Let the witness respond to that. We don't confuse him too much, then I'll allow you to.
Through the chair, for any acting, acting county secretary, provided that he qualifies or she qualifies to act under that capacity, you're given 6 months by law.
Yes, Senator Wandako.
Chair, I just wanted a clarification. Is the county secretary being appointed to act the county secretary that was serving in the previous term, or is a new officer?
Through the chair, is the one that was in the previous government.
My next question, Chair. County secretary served for a fixed term of office on appointment. Had the contract by the time the new county government of Meru came into office expired?
No, it had not expired.
So what was the necessity for reappointment?
The contract was for 5 years, that was expiring actually on 19th of next month. That is the time that is supposed to expire.
Robert?
Yes, Chair. I just needed to get to know benefit of experience. Senator Madnago has picked on the issue. I needed to ask for clarity. Currently, is that county secretary still serving?
Yes.
Has the same county secretary in question is the current county secretary serving, right?
Yes.
And within the contract term, is that the case?
Yes.
Okay, then what was the purpose of extension of the contract as you've discussed in that case? Because if the contract was current for the county secretary and is still serving up to now because that contract is current as per the information you've given, then what was the purpose of giving another letter of appointment or an extension for that matter?
There is no letter that was given through the chair. It's only that Her Excellency Governor confirmed through mentioning the name that because he was serving the former regime, or the former government, he is going to continue working with the current government. That's just what happened. There was no letter of appointment.
Thank you. Counsel, your witness is ahead of you. If you intended to puncture his evidence, you've made him to read the law. He has read it correctly. You have asked him how he interpreted it. He has interpreted it correctly. So you just abandon that and go to the next point.
Point. Because the position the witness has taken on the doc, I told you, is not what is on the documents.
Oh.
I want to show him the documents. Please look, sir, at page 62 of our volume 1.
Yes, I'm there.
62, chair of our volume 1. The pagination is falling on a blackened area, so it's the page after 61. That's a post by the governor, sir, right?
Yes.
Does that post indicate anywhere that the appointment of Rufus was on transitional basis? It's either yes or no.
No.
We played videos yesterday, and Chair, those videos will be Annex 3 and Annex 3A. The transcript will be at page 53 to 54 of our volume 1. In the video utterances, which we don't dispute, were made, was any clarification made that the appointment of Rufus was on transitional basis?
It was made, it was not made.
Good.
And through the chair, on the same
You have answered my question, sir, but if the chair permits, you have no problem.
Yes, through the chair.
Order witness. Why are you volunteering information nobody wants? You've answered your question, wait for the next.
There are some appointments, sir, which we claim were of unqualified persons, including Hilary Sadi, right?
Yes.
To what position did you tell us Hilary Sedi was appointed?
Director of Communications.
Director of Communications.
Yes.
I want you to take you through the governor's documents. What was your explanation, sir? If I remind you, your explanation was just like your post as Chief Secretary. This appointment did not require the approval of the Assembly. Is that still your position?
Yes, it's true.
Please confirm Sandi was appointed at the level of directorate.
I confirm.
So this is a man who is in charge of a directorate in the Assembly, or rather in the county government, the executive side, that is.
I
correct?
confirm.
You confirm. And as a matter of fact, your testimony was that we were erroneous because the advert we are referring to is for a junior position, isn't it?
Pardon?
Didn't you tell the committee that the document at page 76 of the Governor's Volume 2 is for a position that is subordinate to the position Sadi occupies?
It is true.
The Governor's Volume 2, Chair. It is true. Please confirm from this advert that the advert comes not from the office of the governor, but from the County Public Service Board.
That is true.
Confirm as well that the advert invites positions for several directorates within the county government of Meru.
That is true.
Please confirm one of the directorates is at page 67.
That is true.
The other directorate is at page 68 of the advert.
That is true.
There is yet another directorate at page 70, number 5.
That is true.
There is a deputy directorate, now not the directorate, at page 71.
That is true.
There is a directorate at page 73.
That is true.
There is a directorate at page 75.
That is true.
And your testimony in chief was that the position at page 76 is one pack below the directorate. Isn't it?
Yes, it's true.
Sir, I put it to you that it is self-serving for you to claim the directorate that Sadi leads is in the office of the governor, when all the other directorates, the recruiting agency, is the County Public Service Board. You cannot be a witness of the truth.
I'm witness of the truth. I produced the documents that it shows Director of Communication specifically is under office of the governor. Like the case.
Which document was that? Please refer us to it.
I'll refer to document page 83. of the volume 2 of the governor's response. That is one of the positions the Director, Governor's Press Service, or Director of Communication, that is one of the positions that has been put by the Inter-Governmental Technical Committee, which took over from the defiant Transition Authority.
Sir, are you aware you're referring to a different job description? This is Director, Governor's Press Service. That's not the position Sadi was appointed to.
That is the same position. Is where, for example, you can mention the position of Chief of Staff and the position of Private Secretary. That is the same position.
Chair, so that we don't have an altercation, I'm inviting you to note, because by law documents speak for themselves, from the video, from the adverts, it is Directorate of Public Communications, and the explanation the witness is offering is a completely different job description.
Continue. We've seen it on page 83.
Sir, you will also agree with me that in this advert, all persons called to apply for either directorate level or deputy directorate level must have a minimum of 5 years experience.
That is true.
You will also agree with me that Hilary Sandi does not have a minimum of 5 years experience in public affairs.
As I indicated,
either you agree or you disagree, sir.
I don't agree on that.
Good. We've heard your answer, but I put it to you. Neither you, nor the governor, nor anyone has placed material before this Senate to show Hilary Sandi has 5 years experience in public affairs.
Through the chair, my responsibility from the office of the governor was to forward the name of Hilary Sandi to Public Service Board as required by law. The Public Service Board is the one that was supposed to determine whether Hilary Sandi has an experience of 5 years or not. When they give us a feedback that Hilary Sandi is qualified to be appointed as Director of Communications, we did that.
Let's go to the other illegal appointments, sir. Would you agree that all county public offices are regulated by a law?
I agree.
You will agree that if an office is to be created that doesn't exist, the mandate lies with the County Public Service Board.
Not always.
Not always.
Yes.
Sir, is a governor entitled to establish informal structures that are parallel to those that are known to the law?
No.
Good. If the law has established a body to deal with a particular aspect of public governance, is the governor allowed, whether formally through the videos we saw, or informally through the letter you say we don't have, to establish parallel structures?
She is not allowed.
She's not allowed. Would declaration of informal holders, when they are official holders of the mandate in question, undermine the functions of the persons who lawfully are empowered to discharge that function?
Through the chair, the three positions that you mentioned have never had even the governor talking about them in public or elsewhere. It is the removal motion that mention those positions in the motion that we are in. So,
sir, that was not my question, and I don't want to have an altercation with you. My question was whether the establishment of parallel institutions to those known to law would undermine the discharge of the mandate of the official institutions known to the law.
Yes, it is.
Therefore, you will agree, even if we were to accept for argument's sake that there is no appointment letter, the informal declarations whose existence is not in contest was still a usurpation of the statutory and constitutional functions of the bodies mandated to deal with the various issues in the impeachment motion.
Through the chair, it is my evidence there is no informal declaration of any appointment for an existing office so that you can have parallel offices. Throughout the motion that I've read, throughout the response that I've gotten from the council or from the county assembly, there is no such declaration, whereby we have in contest of two parallel offices that are in existence. I have not known of that unless it is produced before this committee.
You are the chief of staff, sir. That's an official position, isn't it?
Yes, it is.
If the governor appointed an informal through a kamukunji or public rally, an informal chief of staff who has no appointment letter, wouldn't that interfere with your official functions?
If it is,
as
it
the
can.
legal chief of staff?
Order, counsel. Counsel. In his evidence, the witness has attached documents, evidence, confirming that those so-called appointments, they never got appointment, they are not on the payroll, the positions they were purported to have been appointed to don't exist in the county government structure. Why are you belaboring when we have so much to deal with? Why don't you?
Chair, I had not gotten to that dynamic of the problem, but I can go to it now that you direct me. Let's start, sir, with all the letters you supposedly wrote to various bodies asking to confirm. And Chair, just to answer your concern, that what I was trying to show the witness is, even if they were right on the facts that there was no appointment letter, it will still be a usurpation of the official functions.
Through the chair, I also want to confirm we went ahead and give the names, the letters of appointment of those that are currently holding the offices that have been mentioned. We revamped on that, and through the response of the governor, we've attached those are currently in those offices.
Let's look at the letter at page 51 of, Chair, I'm referring to page 51 of the Governor's Volume 2. That's a letter by Virginia, sir, isn't it?
Yes.
Has Virginia sworn any affidavit before the Senate?
No.
Has she recorded any witness statement before the Senate?
No.
This document, sir, what is the date on it?
It is on 23rd of November 2022.
And was this before or after the impeachment motion?
It was before the it was after the impeachment motion.
Have you read the date of the impeachment motion before the Senate?
Yes.
It is 5th December. So this date, is it before or after?
It is before.
It is before. You will agree with me, sir. This is a document in response to a memo from you.
Yes.
So your memo equally, the memo being responded to, must have been in existence before the impeachment motion.
It's true.
Did you place that memo before the county assembly?
No.
Did you place this letter at page 51 before the county assembly?
No.
Sir, the answer you have given me, the two last answers, you will agree with me those answers apply to the document at page 53, correct?
It's true.
Those two answers also apply to the document at page 54, correct?
Yes.
The one at 55, correct or incorrect?
It's correct.
When we come to the one on page 56, you will agree it is a document generated on the day, a day after the impeachment has taken place.
It is true.
So these are documents, sir, made after the event.
It is true.
You will agree with me, the same applies to the document at page 57. It's made after the event.
Correct?
At your instigation, sir, isn't it?
Yes.
The one at page 58 was available long before the impeachment, correct or incorrect?
It is correct.
But it was not placed before the assembly.
Through the chair.
Either it was or it was not.
Through the chair. Remember, an issue was discussed and we didn't, or the governor did not do a response to the county assembly of Meru because the advice was given by the legal to the governor. So there is no way that this document that the council is mentioning
I'm waiting
I'm
for
saying
you to
through
finish
the
your
chair,
answer.
I've seen the chair is consulting. I've seen all these documents that the legal counsel is mentioning were not forwarded to the county government of Meru because the legal advisor, the legal team to the governor advised that the governor was not going for the impeachment motion that was in the county assembly. And there is no way the question that the legal is asking, there is no way these documents now could have found their way to the county assembly when there was an advice that the governor was not participating in the motion that was in the county assembly of Meru.
Chair, or rather, Mr. Witness, we are not interested in the legal advice. The legal advice you received is in any event privileged, so we can't even insist on seeing it. My question was simply whether the document was presented before the assembly.
The governor did not attend the impeachment motion at the assembly.
Was she availed the opportunity to present not just this document, but indeed all the documents before the assembly?
She could not forward the documents.
That's not the question. Was she availed the opportunity to present those documents? Now that we agree all of them were in existence, was the opportunity given?
The opportunity was given.
Good.
But she underlined.
We are not interested in the buts. You will have the opportunity to say the ifs and buts in re-examination. Let's go to the document you said it was before the impeachment motion at page 51. Do you know when was the date of the first impeachment motion, sir?
Yes.
What was the date?
It was on the 30th.
It was actually 21st. That year was the debate, isn't it?
Yes.
Therefore, you will agree, even this document at page 51 was made after the event. Never mind, the event was quashed by the High Court.
I agree.
Order. I think the counsel for the governor, I don't know whether you're following this matter. Why is the counsel for the assembly interrogating your client on a matter which is not before this committee? The matter of the first impeachment is not our case here.
Chair, I'm guided. I will just withdraw the question so that we don't take...
Be fair to us.
I'm guided, Chair.
So far, we have gone so well with you, with us, and with the public. Let's give it the seriousness it deserves. We give the people of Meru justice.
My apologies, Chair. Sincere apologies.
Lukumba wacha.
There is the document by Geoffrey, Edward Budi Geoffrey, at page 105. Correct, sir? Page 105 of the Governor's Volume 2.
Yes, it's there.
As a matter of fact, Geoffrey has sworn 2 affidavits, this one and the one that is signed.
Yes.
Was Geoffrey available at the time this impeachment motion was before the Assembly?
Yes, he was available.
You yourself now testifying before the Senate, were you available to testify for the governor when this matter was before the Assembly?
There is no invitation to the county assembly.
The question was whether you were available.
Through the chair, how can I avail myself to something that is not there? Because there is no invitation, there is no request, and even if you go there, you'll be a stranger. How do I avail myself to the county assembly to testify when I cannot be able even to go to that county assembly?
Sir, I want us to play the video in slow motion, your own video.
Council, Chair? Just for my understanding, Council, on that particular question, to take note, does availability in this case means, were you invited and available and was not able to attend, or were you in the assembly? What are you asking?
The point I was hoping to make, Chair, is that the governor was availed the opportunity to testify if she wished to call witnesses, including the witness she has now called, and indeed any other witness she has now brought.
Through the chair, I think from the one go that the governor did not attend the county assembly impeachment motion that was there. So from that point, I'm really confused on what to say in the questions that is bringing that are relating to the impeachment motion that was at the county assembly of Meru.
Chair, with your permission, I think this witness is abusing the latitude that you have given him. Let him answer the question and we move on. This is becoming too much. He's going through the chair more than the chair himself.
Chair, Chair, I'm here, Senator Dhangwa Kiambu.
Yes.
You know, I'm sitting next to Sifuna, and we have agreed that he takes the legal matters and I take the layman's matter. The question probably the council is asking, the time the governor was accorded to appear before the committee at the assembly, couldn't she have sent you there the way she has sent you here? That is the question.
Well, guided, she didn't send me there.
I want us to play a video you played, sir. You played it in slow motion. So let's play the one you played in slow motion of stones being thrown at the governor. And we can pause, Chair, where the stone is right above the governor before it obeys Newton's laws of motion. It can be paused, Chair, right where the stone is right, slightly behind the governor, before it hits the ground.
Council.
Yes.
Council.
Yes.
With a light touch, because it's a long afternoon. Yes. This is a very emotional video.
Fair enough, Chair.
Do you really want to replay it? The committee is naturally,
yes.
sympathizing with the governor that she was going to lose her life.
Fair enough, Chair.
This one does.
Maybe, Chair, should ask me why I want to play it.
Okay, play it.
The reason I want this video played, Chair, let me put the question to the witness so that I don't start testifying. You will agree, Mr. Witness, that the governor's back is facing the precincts of the assembly.
It's true.
You will agree the governor is just outside the assembly.
It is true.
You will agree with me the trajectory of the stone is that it is coming from the face of the governor towards our back.
No.
That's why, Chair, you will agree with me, Mr. Witness, if a stone was thrown in the opposite direction, it would land in front, not behind the governor.
No. I put the...
You know, Chair, I'm a resident of Meru, and maybe the committee doesn't have the benefit of the geography. And that's what I'm trying to show, that the caption on this video, what is actually happening is the reverse of what the caption says. Yes.
Council. On a lighter note, Chair, on a lighter note, the committee as a Gor Mahia fan here who knows the direction of stones.
I am guided, Chair.
Chair, I just wanted to guide Council. Council, there is a lot of meat that you can go after. Because at the end of the day, that stone hits the vehicle. That tells you where the stone is coming from.
Yeah, but the
because
problem, Chair, I have is that the caption misleads you.
Just a minute, Council. If that stone bounces off the vehicle, it cannot have originated from in front of the vehicle to bounce off the car, then go into the assembly. You understand?
It's not bouncing off a vehicle.
Play the video. Just play the video. There's two stones.
I'm talking about the stone, the specific stone. A specific stone. Anyway, Chair, so that we move, I don't have to...
Council.
Yes.
I think everybody knows what is happening in that video.
Yes.
You don't have to be a student of physics like the few of us here to know that that stone was flying from the county assembly, past the lady, and hitting the car. So just...
Anyway, we'll leave it to interpretation, sir. I'm just saying, as a person who lives in Meru, it's the other way around, but we don't have to be detained.
But the stones of Meru are also subjected to Newton's laws of motion.
Chair.
Let's move, Chair. It's not a critical matter. I don't want us. And Chair, since a lot of my time has been taken in the interjections, I'll pray for 10 extra minutes from the 30 I have. And I pray at this point, Chair, I pray at this point you allow my learned friend, Mr. Sheikh Abdikadir, to continue the cross-examination.
Thank you. We thank you. Abdikadir, you have 28 minutes.
Thank you, Chairman. No, it's okay. I'll do it from here. Good afternoon, Mr. Harris.
Good afternoon.
You said you are the Chief of Staff.
It's true.
Do you have a letter of appointment?
Yes, I have.
How were you recruited? Were you interviewed by the County Public Service Board?
Yes.
You were interviewed by the County Public Service Board?
Yes.
You are in charge of the governor's staff, but not the county staff?
Yes.
Do you know who is the head of the public service in the county?
Is the county secretary.
Okay. In your evidence in chief, you played a video where you implied that the Speaker of the County Assembly is not a member of, is not an MCA. Is the Speaker an MCA?
He is not.
Chairman, I would like to refer the committee to Article 177(1)(d), and perhaps if the Council can give the Constitution Article 177(1)(d) so that he can read to the committee.
Chair.
Council, can you help Daktari, yeah. Can you please read Article 177(1) all the way to D, A, B, C, D?
A county assembly consists of A. Members elected by the registered voters of the wards, each ward constituting a single member constituency on the same day as the general election of the member of parliament, being the second Tuesday in August in every fifth year. Number B, the number of special seat members necessary to ensure that no more than 2/3 of the membership of the assembly are of the same gender. Number C, the number of members of the marginalized groups, including the persons with disability and the youth, prescribed by an act of parliament. And number D, the speaker who is an ex-officio.
Thank you. Chairman, I wanted to draw the attention of the committee, particularly to...
That is the composition of the county assembly, not MCAs.
Thank you. 1D. Pass me the... No. The bundle. The one we're sharing.
Chairman.
No. The other one.
You know, yes, where statement of fact and the law, as a reference has been made for the witness to read, and it clearly states on the heading, the members of county assembly consist, those are MCAs. So we would like, because of the record, to make sure that whatever references has been made, the witnesses needs to acknowledge, because this point of law, it's not a speculative statement.
Chair, also to add on that, just maybe it was not clear to the witness, he can as well read the County Government Act, Section 7.
Thank you, Senator. In your affidavit, you talked about the Ward Development Fund, and in your evidence in chief.
Yes.
In the previous regimes, were there ward development funds?
I was not I was not privy to the information.
Do you know what the Ward Development Fund is for?
Yes, the information that I know is the one that is being discussed on whether to be interested in the constitution or not, like the CDF that is at the constituency level.
Oh, okay. So you think it's similar to the CDF?
Yes.
The County Government Act, one of the objectives is devolution is to allow people to make decisions affecting them.
Yes.
Do you agree the members of the County Assembly represent the people?
I agree.
Between the executive, the governance branch and the assembly, who represents the people?
Between, pardon?
Between the governor and the assembly, who represents the people? Who has the power of the people?
The MCA.
Do you know the function of the county assembly?
Yes.
Can you tell the committee what it is if you know?
There is the registration, there is oversight, and the representation.
Will you say this impeachment is part of oversight?
Yes, it is.
Order, Council. Speaker, you know why I'm calling you Speaker.
Yes, I know.
In our other lives, I work
Yes,
with you as
true,
our Speaker
true.
in Mandera, and I respect you so much. But let the records be correct. As far as the Constitution is concerned, Article 1, all democratically elected people are representatives of the people. So if it is about this process that is ongoing, the MCAs are representatives of the people, they are democratically elected, just as the governor and the MPs in Meru County.
Guided chairman, but I was asking in the context that in the affidavit of the witness, where he has said that the governor is protecting the people of Meru, and in several places in the response and in the affidavit it has been said that the MCAs are going for their selfish interest and the governor is protecting the people of Meru. I'm trying to bring out, as much as the governor is representing the people of Meru, are equally the MCAs.
If that is the case, we have no objection. Edwin was just, sorry, not Edwin, Senator Sifuna was just reminding me of a ruling a few months ago where it was found that the governor, having been found in the Constitution by that court, that to be a governor you have to have the same qualifications like an MCA. So you're perfectly correct. Yes.
Thank you, Chairman.
The pilot is refusing. Why? That was the court, not me. And I was reminded by Senator Sifuna.
Thank you. In your affidavit, paragraph 43, and this is volume 4 of the governor's bundle, in your affidavit you said that the county assemblies have failed to undertake their work, such as refusal to approve the CECs. Do you agree that even rejecting the CECs is part of their work and they're doing their work?
They gave a demand.
That was not the question. The question is, by rejecting the CECs, are they doing the work they're meant to do, or they're
Yes,
not?
they are.
Thank you. In your affidavit, you talked about the public participation And you played also a video.
The council is now starting to overuse my latitude. So council, don't give evidence.
I am guided, Chairman.
Perhaps, Chairman, I rephrase that and I ask the witness. Witness, do you agree that the county assembly holds public participations when they are doing bills, budgets, removal of office of CECs, and major projects in the county governments?
I cannot confirm.
Order, and even that one is not admissible. That is a leading question.
The leading, about cross-examination, about leading questions.
Order. You can ask the same question and get the same answer. You don't have to lead.
Chairman, with a lot
You're
of
telling
respect.
the client, not the client, the witness, to say it the way you want. Put your question and let the witness then give you the answer that you want. If you can't, we can't help you.
Chairman, I have a lot of respect for the committee and the chairman, but we have to agree on the ground rules. Evidence in chief is where leading is not allowed. And there are a lot of councils in the house and they will disagree with me. But in cross, it's about leading questions.
So, you want us to agree with you, council, that you do what you want, and then we find fault when we are writing the report, and in the process, to your detriment. I was helping you so that you can come out best, so that all of us can accommodate your evidence. We don't want to kill it technically.
Absolutely.
So
Yeah,
I'm
maybe Honorable Sifuna can guide the committee. Actually, council is right. The rules are the other way around.
Chairman, I got the
But
point.
I don't want to be saying it from this side because I think what my colleague is saying is that leading questions are allowed in this phase. It is in the other phase they are not allowed.
Okay, fair enough. You proceed. My team of legal advisors will advise us. Just proceed.
Chairman, it's the last thing I wanted to disagree with you, but
Proceed. Abdi.
Witness, you said in paragraph 21 of your witness statements that the minority leader, Honorable Mwangaza's statement refers to false public outcry for the governor to sit down with the elected leaders, yet the governor